hearing. Would you like to make a brief opening statement before we get started for questions?
Certainly. Michael Cooley-Smith, Chair of the Criminal Law Committee of the ACT Law Society. The Society in our submission have identified a number of issues that I suppose we have in relation to the bill in its current form. The first of those is the interaction or possible interaction with the Commonwealth Criminal Code and the possibility that it will remain an offence in the ACT irrespective of the intention of the bill that it not be an offence for possession of cannabis under 50 grams or natural cultivation of 1 to 4 plants by an individual. We have concerns that wouldn't excise the Commonwealth offence provisions, in particular 308.
Sorry, it wouldn't?
Would not,
sorry,
yes.
Thank you.
And the other issues we've identified, one is similar to a number of the other submissions that you have before you, namely the issue of weight, the 50 gram weight, and the possibility, or in fact what we would think likelihood, that if the person had up to 4 plants, they could easily exceed the 50 grams in harvested product from those plants. That's particularly the case where the proposed legislation deals with natural cultivation only. Obviously, we live in a particular climatic conditions in the Territory. It's absent artificial cultivation. It seems likely that plants are going to die at times of the year. And if they
be concerned about that?
Well, if they do, the product then falls, the leaves fall off, the person retains them. Should they be found criminally liable because the product they retain, it goes over the 50 grams, when all that's happened is the death of the 4 plants they were lawfully growing up until the point they perished. That's the issue that we foresee in relation to that. The other concern is in relation to, unless there is some legalisation in relation to obtaining seed, it seems that the legislation itself may be promoting criminal activity, because there would have to be what would still constitute a traffic in cannabis, albeit the person receiving the drug isn't the person guilty of that offence, but they are at least promoting the offence by purchasing the drug to cultivate their own plants, which will be lawful for them to do. The other issue we identified was in relation to the drug driving laws and how the drug driving laws in the Territory operate effectively on a zero tolerance basis, but these laws operate on a permissive for personal use basis. And that creates a potential conflict, particularly with a drug like cannabis, which remains in a person's system for some time as detectable, and that is at least a matter of days. And it may be that the impairment has since passed, but the detection can be made, and therefore there's an apparent conflict between the laws. The Law Society has no difficulty with it being illegal, and I make the point that the Society has no difficulty with it being illegal to drive whilst impaired by cannabis. What we are simply saying is if cannabis is going to be legal at some level, there needs to be thought to making the drug drive laws operate in a way more consistent or more similar to the laws in relation to alcohol and driving. So, and there clearly the alcohol is freely available to adults in our community and can be freely consumed by adults in our community, but we still quite rightly have drink drive legislation that regulates and punishes people for the degree of impairment that they actually have, rather than just that they have engaged in their lawful right to consume a single drink, and that's effectively we're concerned the same thing could happen with the cannabis legislation, that a person lawfully has a joint one evening, they may not be affected at all the next day, However, under our current drug drive laws, it's clear they would almost certainly, if they were pulled over, be detected and guilty of an offence that is punished as though it was a level 4 drink drive, which is the highest drink drive offence or the harshest drink drive offence that we have in the territory. So that's the concern that we have there. Those are the main concerns that we've identified in relation to the bill, and I'm happy to answer questions in relation to those or other matters.
I have a couple of quick questions. So just quickly picking up on that drug driving legislation, and I think you rounded out what I was going to ask, but I might just still ask the question anyway. Do you know of other jurisdictions where cannabis has been legalised and they do have an ability to test?
I believe they do in Canada, but I don't know the details of the Canadian. They certainly test, and what they criminalise in Canada is impairment. So to that extent, that is the basis of their system. But I don't know at a testing level, because I know that's what police have raised as a concern in response. I'm not sure whether in this committee, but certainly publicly, police have raised responses to what we've said in relation to drink drive legislation as a comparison, saying, well, they don't have the technology to test. I don't know how Canada deal with that issue, but I do know that the way they criminalise it is based on impairment as opposed to simple presence of the drug.
Thank you for that. I just also wanted to touch on a part you mentioned in your submission about persons under 18 years old and how that impacts. It's a one dot point. I was just wondering if you could maybe expand on. You've just said that the society supports the clause is included with the meaning of a simple cannabis offence. So I guess you're agreeing that under 18 they should just still receive what's commonly known as a SCON. Is that correct?
Well, it's a matter for the Legislative Assembly as to whether people under 18 should. Certainly we wouldn't want to see it become more criminalised as a result of this. That's I think the point. It's ultimately, and we accept it's an appropriate decision, and defer to the Legislative Assembly as to whether what the age should be in relation. It seems it certainly seems consistent with the legislation in relation to alcohol and other legalised products, and we just don't want to see an increase in penalty that results in children going to court where they wouldn't otherwise.
Because, and correct me if I'm wrong here, happy to be corrected. Currently, if a minor, for want of a better terminology, is caught smoking a cigarette, there's no threat of imprisonment or thousands upon thousands of dollars of fines for that minor.
The issue is certainly in the years on. 15 years I've personally been in practice, the only charge I've ever seen related to the person who sold the person those and the offence they committed, not the individual. And
you would see possibly there could be a correlation between, if cannabis was legalised, there could be a correlation between that.
Yes. Yep. And the same can be said of alcohol as well.
Yes.
That there aren't offences per se for the consumption of the alcohol by youth, but there's certainly there's offences in relation to the attempts to purchase and offences in relation to the sale itself.
That's correct, yeah. So I just wanted to clarify those issues. Mrs. Dunn.
Thank you. Mr. Kakula-Smith, I'd like to go to the issues that you raised about the Commonwealth Criminal Code. And it was put to the committee earlier this week that the possibility exists, and I hope I'm not paraphrasing or being too unloyally about this, that what we risk doing is creating a vacuum, so that by taking away the ACT offence, then you actually sort of, in a sense, make the Commonwealth offence more prominent, and that there is always the capacity for people to be charged under the Commonwealth offence.
I think that's a fair characterisation.
We've actually vacated the field. We would have vacated the field.
Yes. The two provisions in the Commonwealth Code that deal, so there's the offence provision itself, 308 of the Criminal Code, and it then deals, or 308.1 of the code, and it then deals with, in its own subsections 3 to 5, the preserving of, or certainly not the Commonwealth covering the field if there are comparable offences or diversionary schemes within states and territories. So the Commonwealth took a decision in 2005 to allow for diversionary schemes, etc., within states and territories and not cover the field. So that seems to be an intention by the Commonwealth not to cover the field. However, it seems premised on the basis that there is actually a scheme there, and that seems confirmed by 313.1 of the code, which provides for defences, but the circumstances in which it provides for those defences talk about recognising legitimate use, etc. Now, in our current offence provisions, even in the proposed amended provision, if one looks at what's proposed in relation to 171, capital A, the possessing cannabis offence, subsection 3 of the territory currently and as proposed precludes sections 1 and 2, the offence provisions, from applying in circumstances if a person is authorised under medicines, poisons, therapeutic goods or another territory law to possess the substance. It seems to deal with express authorisation, and that's certainly what the Commonwealth Criminal Code dealt with in 313 and 313.1. The explanatory memorandum for that provision talks about the defences being designed, defences are required to recognise legitimate uses of controlled substances in our community. These legitimate uses are authorised through licensing or permit schemes established under health, industrial or other regulatory schemes. So the Commonwealth Act seems to be predicated on there being express authorisation rather than simply silence.
Right.
The concern is then how does one, as a matter of statutory interpretation, deal with this scheme if it was to come in as it is? And we feel that is ambiguous, and therefore, and it may be that judges decide that no, we're not going to permit the Commonwealth because that just seems unjust, but maybe they can't come to that. Maybe they feel that's the conclusion, but as a matter of statutory interpretation, they just can't get to that conclusion. Our position is if that is the intention of the legislation, it would be preferable that it be expressed in the legislation. So, for example, where now we have that subsection 3 talking in the proposed legislation, looking again at 171, capital A, where it talks about that express authorisation, it could also perhaps include a further subsection that says this Act authorises the use of cannabis by individuals for personal purposes, or to possess cannabis for personal use or personal purposes, less than 50 grams. So actually expressly stating that it's an authorisation in the legislation would seem to at least avoid vacating the field, because the Commonwealth don't seem to have expressed a desire to cover the field themselves, but in the absence of any other law, and that seems to be the issue, and the Law Society's concerns were raised. We didn't know the position of ACT policing until earlier this week when the submissions to this committee became public. But when we became aware of that, it confirmed and reinforced our concern that, because the other way we'd envisaged and discussed in our submission dealing with it was perhaps a memorandum of understanding with the police, but if they feel that they're bound by it, I'm not sure, and the society is not sure that would necessarily be sufficient if the Chief Police Officer is what it's stated to be, or appears to be from the submission, and I know the Chief Police Officer hasn't formed a conclusive view, it seems, on that. It just seems to be expressed as a concern that they may, but it seems that's something that if it can be dealt with by way of legislation, it would be better that it be certain.
To be explicit.
Yes.
Okay. Yeah, that's interesting.
It's very interesting. I was going to ask you all about this. So I guess would you?
Good, I got in first.
I guess given what you've just said, would your advice be A, to make the changes as you suggested, and B, try and have soon afterwards a test case so that we.
I would think if the changes are made, the test case, I think it'd be undesirable to go to it. I mean, a test case implies there's a period of uncertainty and someone has to be the guinea pig.
Yeah.
Yeah, no, but I thought you were giving the impression that you thought there was uncertainty.
Well, I think there is, as it is. If it was legislated to authorise, then I think...
legislated to authorise, my
view and that of the societies is that would then mean that the Commonwealth, for the Commonwealth law, because it is presently permissive of what is authorised in the states, it would then satisfy the current state of the law. There is always, of course, the spectre of a 122 constitutional challenge or use of power by the Commonwealth to overrule, but it would, on our reading, require the Commonwealth to take legislative action to do that. Whereas the current legislation, it doesn't necessarily need the Commonwealth to do anything for people to start being charged with the Commonwealth offence.
And I mean, yes, what you're saying is the Commonwealth can always rule something we've done outside. I mean, yes, they've done it with euthanasia. So,
yes, and they've done it with civil unions in the past.
Civil unions.
Yes.
But in that instance, no individual then gets prosecuted. We just we merely get told, no, go away.
Yes, correct. So it at least gets resolved as a matter of intergovernment and legislative action rather than involving the arrest or charging of an individual.
Yes. So it's
I wouldn't mind just following up. The idea that you've expressed is that the legislation would require to create a permission structure rather than to be silent on the subject. Is that a usual course of action in your experience in the criminal law?
I can't think of many examples where it's where there are exceptions to what is otherwise a criminal offence. Yes, because there are often authorisations for certain individuals to have. So, for example, there are authorisations that allow police to carry firearms that are of a category and type that are prohibited in other circumstances. Capsicum spray or cerium spray is another one of those examples where it is clearly a prohibited weapon, but there are express authorisations that permit individuals, in that case the police, to have them.
I'm just trying to explore that that permission structure that you're talking about is often.
It's often defined, yes, at a class of person.
At a class of person where this is a permission structure for anyone over the age of 18.
Yes, and
it will be
unusual.
That would be unusual.
Yes.
You talked about supply of seeds, which would be part of this regime. Would your concerns be less if they were not supplied for money, if they were gifted?
Still constitutes the effect of it still makes out the offence of trafficking.
Okay. I assume then the only legal thing to do would be to grow your own seeds as well, because presumably as long as...
You've got to have seeds.
Oh, yes. You've got to have seeds to the first instance, but if we forget about the first, once you've established, you would then legally be able to continue.
Yes, the issue seems to be how
to get started.
How to get started. Absent sort of immaculate cultivation, it seems they're not going to...
And if there's only 2 plants required, keeping a consistent supply of seeds would be challenging.
Sure.
I'll defer to you.
Yeah, I was going to say.
Your professed greater expertise on the subject than me.
It's just on the card now. We have male and females.
Do members have any other questions?
Yes, I do. I also wanted to. No, actually, you covered the question of drug driving.
Yes,
And
I did.
You
impairment.
talked about
Yes,
that.
sorry,
Yeah.
sorry.
I think
No, that's.
I'm right.
Yep. Excellent.
Thank
Well,
you. Yeah, thank you for the submission.
yes, thank you. And thank you for your evidence today. We've found it extremely interesting. When available, a proof transcript will be forwarded to you to provide an opportunity to check transcript and suggest any corrections if available. I don't think there was any.
No.
On behalf of the committee, I would like to thank you for appearing today on behalf of the Law Society of the ACT.
Thank you.
Thank you.
Thanks a lot.